It's Nolan. Now, before we get started, make sure y'all hitting that like button. Make sure y'all sharing it on your respective platforms. Let somebody know what we're doing today. Now, let's get into the show.
Yeah, lot of controversy that do not disturb me. Got dreams of a million, you cannot defer me. Got a ring on my finger, I retired my jersey. Fuck, nigga, y'all suck like the plot of Kirby. I'm him. All black on the scene, doing me high. No, I got the game covered like knee highs. I be killing all my foes like FIFA. Flows on kit like FIFA. Feel like EIO. Green on me like G.I. Joe. Hold my chest like a peacock glow. Southside nigga with an east side hoe. Hitting at the chicken number 3 combo. Type of nigga lead EB John Doe. 3D Camp Creek on the creek zone 4. With a nigga play street. Living cheeks on the floor. Can't speak no more. First verse in surgery, it's only me versus me. Nobody else hurting me. I burn niggas to the 3rd degree. Like Jazz O, niggas certainly. The best nigga that rap, I don't mean just virtually. These are the 4 just worker bees. I flex up like Hercules. I hit a nigga in the shit so hard that it hurt to sneeze. It's Nolan.
What's going on, beautiful people? It's the kid J Nolan here. Welcome back to another episode of Inside the Industry, your number one source for music, entertainment, commentary, and breakdowns. Hope everybody's doing well out there. In this video, we're going to be picking up on Cardi B and Tasha K. We know that they've had a very deep history over the course of this last 8 years, just about, for Tasha K defaming her and her children, her family. She has to pay nearly $4 million for the defamation. She's been trying to squirm and get out of it and all of this different type of stuff. She's also been ordered to I won't even say ordered because she proposed it. She proposed a non-disparagement clause that came with her bankruptcy, right? Because all of this is tied to her bankruptcy. She tried to file bankruptcy to try to evade having to pay, which was not successful. And she agreed to not speak about Cardi B, her family, her love interests, known associates and friends that are in her inner circle. Not so much as people just in the industry who might happen to be casual friends, but people that are in her inner circle. All of these things were agreed to by Tasha K. And I must emphasize, not only agreed to, but proposed by Tasha K. In this agreement that they have, this payment plan that they have in order for her to pay Cardi all of the money that is owed. Okay? So it was just a few days ago, we read through Tasha K's reply for sanctions, right? Because she violated the non-disparagement clause, right? Cardi B and her legal team had more than 25 citations of Tasha K violating the non-disparagement clause. They reached out to the courts for sanctions. They also wanted to try to get preemptive sanctions on her for future violations because they don't have any good faith that Tasha K is going to live up to her promise because she's violated it 25 plus times, not to mention all of the times that she did it prior to them actually documenting it, right? Because for the last few years, she's been talking about Cardi B and trying to use code language like the Latina or my sister or different things, right? And I don't even watch this woman's productions. I just happen to see it whenever she speaks on Cardi B, it gets filtered into my timeline. So I can only imagine what I haven't seen, right? And Cardi B said, not no more, enough, right? She came out earlier in the year and issued a warning to Tasha K saying, hey, I've been letting you slide. I know you've been talking shit about me. I know everything. I've been letting it ride, but I'm about to hit the court and put the hammer down on your ass. The hammer has indeed come down. Okay? So Cardi and her legal team filed a response to Tasha's response a few days ago. I didn't get an opportunity to read through it. I guess I'll do that today. And Tasha also came out last night and basically admitted defeat, talking about how her lawyer is now going to be responsible for 10% of Cardi's legal fees. and that these sanctions are going through. As of yet, the paperwork has not been submitted for me to be able to verify the judge's order. I don't have that on hand at this time. It may come through tomorrow. It may come through Saturday. It may come through Monday. Just going to have to stay tuned for the official order from the judge. But she decided to jump out in front of it and monetize by going on her platform and talking about it and trying to make light of the situation, which I find to be incredibly weird, right? But if I had any understanding or if there was any sense to be made of her actions, she probably wouldn't be here in the first place. So again, this is Cardi's rebuttal. It says, creditor Belcalis Marlenis Almanzar, through undersigned counsel, respectfully submits this reply to debtor's response in opposition to motion 1, enforce confirmed plan and confirmation order, and 2, award attorney's fees and sanctions. Preliminary statement. Debtor is not a disinterested entertainment and gossip columnist who stumbled into a legal gray area. She is the adjudicated author of a malicious years-long defamation campaign against Ms. Almanzar, a campaign so deliberate and so damaging that a federal jury awarded nearly $4 million in compensatory and punitive damages. I don't know how she forgot that part. That judgment is non-dischargeable. It will follow her, and it was the singular reason this bankruptcy case came before this court. The non-disparagement clause in the plan and confirmation order was not a peripheral condition of the confirmed plan. It was, as undersigned counsel stated on the record at the confirmation hearing, really critical. The product of weeks of hard negotiation and the essential quid pro quo for Ms. Almanzar's extraordinary concession and agreement to stay enforcement of a nearly $4 million non-dischargeable judgment against Ms. Kibi, her husband, and Yelling Entertainment. It got to be embarrassing as fuck to know your husband is on the hook, as a husband, to be on the hook for some shit your wife got into with her mouth, and then trying to transfer everything over to your business to try to evade the penalty. Ain't that about a bitch? But hey, I hope y'all are doing well at home. Without that clause, there was no consensual plan. Without Ms. Almanzar's consent, there would have been a hearing on Ms. Almanzar's motion to dismiss, and this court had already made clear what was at stake. On January 9, 2025, at a hearing held before the plan was confirmed, this court addressed counsel with unmistakable clarity. This is the judge. This is what I was telling y'all about before. We are going to have an evidentiary hearing, and I will tell particularly Mr. Van Horn, if Mr. Moon proves even half of what he alleged, not 10%, the case isn't being confirmed and is being dismissed. I mean, it's really, Mr. Van Horn, you hit the nail on the head. It's going to come down to credibility because the allegations are damning, okay? And if he proves even a fraction of them, the case is over, okay? But I think we need evidence. But I hope your client hears me loud and clear. There's a lot he's alleged. He does not have to prove all of it. He can prove a handful of bad acts, misstatements, statements under oath that prove not to be true, failure to have real projections, any host of things, you know. And Mr. Van Horn, you can read 1129A just like I can, and you see what you need to prove, and you may miss any one of them, you lose. And Mr. Moon's arguments, if he can prove any of this, and he suggests he has the evidence and it's in his motion, so it would be on you to convince me that that's not the facts. He's going to win, and this is going to be case over. So I don't know what else to say. Debtor and counsel heard those words. She then accepted the non-disparagement clause to preserve the case. She cannot now, through a contempt response, attempt to rewrite the obligation she knowingly and voluntarily accepted to avoid her case being dismissed. So they were going to throw out her bankruptcy altogether. So this is what kept it intact. And now she's trying to exploit it. Yet that is precisely what the response asked this court to do. Stripped of its rhetoric, the response makes 3 requests. 1, reinterpret the non-disparagement clause to exclude the very conduct it was designed to prohibit. 2, treat a narrow, specifically defined cure mechanism for unknown family members of Ms. Almanzar as a general license to post and delete prohibited content at will about Ms. Almanzar and or her known family members, and 3, invoke First Amendment doctrines that have no application to the enforcement of a consensually negotiated, court-confirmed contract. The law forecloses all 3. And I know I'm going to be saying it numerous times in this video, but I do not believe it can be mentioned enough that Tasha K proposed and agreed to these conditions. Cardi B did not submit this non-disparagement clause to the courts. This was a remedy from her team. And she has yet to figure it out. Debtor has demonstrated through her own words and in public broadcasts to hundreds of thousands of followers that she only agreed to the non-disparagement clause under duress of dismissal and never intended to honor it in spirit. She has made clear she resents it, views it as an obstacle to be overcome, and intends to continue as to escalate and resume the very defamatory conduct that generated the $4 million judgment once the plan terminates. These are not the actions of someone navigating an ambiguous order in good faith. These are the actions of someone of ill intent who is trying to weaponize a cure provision as a revenue-generating business model and is asking the court to ratify that conduct as compliance. This court should decline that invitation. A confirmed plan is a court order. Notwithstanding debtor's delusional belief that the law does not apply to her, willful violations of court orders must have consequences. This reply demonstrates that each of the legal arguments advanced in the response is either foreclosed by controlling 11th Circuit authority, contradicted by the plain text of the confirmation order, or refuted by the very cases on which the response purports to rely. And perhaps most shocking, as discussed further herein, the response includes reference to what appears to be a fabricated or hallucinated case, and otherwise includes citations that do not even remotely stand for the proposition cited. All right. Argument: this is a contract enforcement case, not a First Amendment case. So they like, you keep screaming out First Amendment. This ain't even about that. The response devotes substantial space to First Amendment doctrine, prior restraints, the near decision, Milkovich, and a sustained argument that prospective sanctions would unconstitutionally chill protected speech. This entire framework rests on a false premise. The non-disparagement clause is not a government-imposed restriction on an unwilling speaker. It is a voluntary contractual concession negotiated at arm's length, accepted through counsel, and incorporated into a court-confirmed plan as the price of preserving debtor's bankruptcy case. The First Amendment's prior restraint doctrine, developed in cases like Near v. Minnesota to protect the press from government censorship, has its greatest force against restrictions imposed by the state on unwilling speakers. It has its weakest application, if at any at all, to voluntary contractual obligations. Okay? Which is what we've been saying all along. You agreed to it. You proposed it. This is not a violation of your First Amendment rights because you chose this route. Debtor was not compelled to accept the non-disparagement clause. She willingly but deceptively accepted it in open court because the alternative was losing her bankruptcy case. The Constitution does not grant a party the right to breach the contracts they voluntarily made. The response itself confirms this is a contract enforcement dispute. Debtor acknowledges that the clause was negotiated, that the plan was confirmed, and that debtor received its benefits. The January 9, 2025 hearing transcript makes the consideration undeniable. This court told debtor and her counsel in no uncertain terms that the case was over if the undersigned proved even a fraction of his allegations. Debtor accepted the non-disparagement clause to prevent dismissal. Having received the benefit of that bargain, a stay of enforcement of a nearly $4 million judgment, she is bound by its terms. Okay? So they have like a long payment plan in order for her to pay this off. Otherwise, they would have just demanded it all at once or as much as possible. Accordingly, the court's analysis begins and ends with one question: Has the debtor complied with paragraph 14 of the confirmation order? The overwhelming, largely uncontested record demonstrates that she has not. The non-disparagement clause is not ambiguous, and debtor's argument to the contrary is an improper attempt to relitigate confirmed plan terms. The response argues that the non-disparagement clause is ambiguous, is applied to commentary on public figures connected to Ms. Almanzar, and that this ambiguity precludes a contempt finding. This argument fails on every conceivable level. Here we get into the plain text of paragraph 14. Paragraph 14A of the confirmation order states in plain English that the debtor shall ensure that no content related to Ms. Almanzar and or her family, whether explicitly or implicitly, will be published or disseminated on any of the debtor's social media accounts, websites, blogs, or any other online communication channels. The word implicitly does not appear in the order by accident. It was drafted and negotiated to cover precisely the methodology debtor has employed throughout the life of this plan. Coded but obvious references, contextual clues, crowdsourced identification, and thinly veiled commentary that her audience of over 1 million followers immediately and universally understands to be about Ms. Almanzar. Debtor argues that the confirmation order does not answer when commentary on a third party like Almanzar's husband, Offset, becomes a prohibited implicit reference to Ms. Almanzar, but the order answers that question directly. No content related to Ms. Almanzar or her family, whether explicit or implicit, is permitted. The gap debtor identifies does not exist in the text. Debtor has simply and disingenuously attempted to manufacture ambiguity in a provision that is clear. The 11th Circuit's ambiguity standard requires that an order be susceptible to two different reasonable interpretations before contempt is precluded. There is no reasonable interpretation of no content related to Ms. Almanzar and or her family, whether explicitly or implicitly, that permits defamatory posts accusing Ms. Almanzar of witness tampering, not to mention the 16 consecutive posts about Ms. Almanzar's husband following a nationally publicized shooting published by the person who was adjudicated to have defamed Ms. Almanzar for years. The only reasonable interpretation is the one the text actually states. And this is to say nothing of the indirect coded references to Ms. Almanzar herself, which were raised in the motion and supplement, even in the context of what debtor would have this court believes are innocent references to Offset regarding what debtor considers newsworthy commentary. For example, when disparaging Offset as a result of his alleged gambling issues, debtor mockingly observed in one of her posts, he. So Offset was at work. You know, Offset works at the casino. He is down there 5 times a week, clocking in. Some days he works first, second, and third shifts, and he uses everyone else's money to gamble with. Okay, I was told he would probably still be in a certain relationship if he wasn't gambling away all that money. Ain't no other way to slice or dice that one. The he is crazy. Of course, her followers immediately understood that once again, debtor was making reference to Ms. Almanzar's marriage with Offset and issues that led to their separation. A proponent of consensual negotiated plan clause cannot claim it is ambiguous. Ambiguity doctrine exists to protect parties from being held in contempt for conduct they cannot reasonably have understood was prohibited. It has no application here. Offset was specifically discussed by name during the negotiation of the non-disparagement clause before plan confirmation, which is what I've been saying the whole time. The motion establishes this. The third violation notice quotes it. Debtor's response does not deny it. A party who negotiated a specific prohibition cannot claim she did not understand that it prohibited that specific conduct. The non-disparagement clause is as unambiguous as it could possibly be. No content related to Almanzar and or her family, whether explicitly or implicitly. Because they knew you was going to be on bullshit. Moreover, the Supreme Court was explicit in United States v. Rylander. It would be a disservice to the law if we were to depart from the longstanding rule that a contempt proceeding does not open to reconsideration that legal or factual basis of the order alleged to have been disobeyed and thus become a retrial of the original controversy. What debtor asked this court to do in her response is precisely that: relitigate what the non-disparagement clause means, conducted through the back door of a contempt defense. The time to contest the scope of the order was before or at confirmation. Debtor accepted the terms. She is bound by them. At the February 24, 2025 confirmation hearing, Ms. Almanzar's counsel stated on the record before this court that there was quite a bit of negotiation that went on, certainly late, but we got where we needed to get with the non-disparagement clause, which was really critical considering the nature of the defamation judgment that had occurred. The court confirmed the plan with that representation on the record, a provision that was really critical, heavily negotiated, and specifically addressed to this court before confirmation is not ambiguous. It is the central defining condition of the agreement. Debtor's attempt to claim confusion about its scope 14 months later after over 25 documented violations is not credible. All right, man. This here gonna be the last section that I read of this shit, because they're gonna repeat themselves about 30 more times in this motherfucker, as they should. But as I won't, okay? So here they get into Offset and Stephon Diggs. The cure provision of paragraph 14B is inapplicable to the violations at issue and does not constitute a general license to post prohibited content. The response's most fundamental legal error is its treatment of the paragraph 14B cure provision as a general compliance mechanism that somehow validates debtors' post and delete cycle as good faith performance. This misreads the plain text of the provision in a manner that no reasonable construction supports. So remember, Tasha K was basically saying, I can post it as long as y'all let me know that it's a violation, then I can still delete it within 24 to 48 hours. And if I delete it, then it's all good faith. They saying, fuck no. Okay? Paragraph 14B provides a cure mechanism applicable only when a prohibited comment is made with respect to an unidentified Almanzar party, defined as a family member of Ms. Almanzar not known to debtor and or the general public to be related to Ms. Almanzar in that narrow and specific circumstance, and only that circumstance concerning an unknown family member, debtor has 48 hours from receipt of notice to remove the content. Not one of the violations cataloged in the motion and supplement involves an unidentified Almanzar party. Offset is Ms. Almanzar's husband. He was specifically discussed by name during negotiation of the clause before confirmation. He also threatened to sue this woman, by the way. Stephon Diggs was Ms. Almanzar's publicly reported romantic partner and is the father of one of her children. Ms. Almanzar herself requires no identification. The cure provision, by its plain terms, has zero application to any of the conduct at issue. Debtor never engages with this textual reality in the response. Rather, debtor describes paragraph 14B as a general enforcement mechanism, which it is not, and builds her entire knowingly false good faith narrative on a provision that does not cover the violations she is defending. The motion's characterization of debtor's conduct as a business model is not rhetorical hyperbole. We heard a lot about rhetorical hyperbole these last year and change. It is an accurate description of what the record shows. She posts prohibited content about Ms. Almanzar and her family, generates tens of thousands of views and advertising revenue, waits to see if a violation notice arrives, removes the post after the damage is irreversible, and repeats. The 11th Circuit addressed exactly this pattern in FTC v. Leshin, holding that retransfer of contracts after the violation did not cure it because the violation had already occurred. And would you know, in the parentheses here, they said Tasha and her legal team even cited this case unknowing that it actually debunked their own retort. You couldn't write this shit up in a movie script. The violation is complete upon publication. The sanctions attached at that moment. Post-publication removal is not a cure. It is the final step in a profitable cycle for debtor. Furthermore, in Howard Johnson Co. v. Kamani, the 11th Circuit held that defendants who deliberately sought a name that would be close to the plaintiff's name, yet not infringe, testing the boundaries of a court order rather than honoring its spirit, could not invoke a good faith compliance defense. Debtors' thinly coded references, crowdsourced audience identification, and tactical use of obvious nicknames and contextual clues are the precise equivalent of testing how close to the line she can get without technically naming Ms. Almanzar. Howard Johnson supports the proposition that this approach is itself contemptuous. So as y'all are able to see, Cardi B and her legal team put their foot, ankle, damn near to the knee, all the way up Tasha K's ass. And here we have a video response from Tasha K about matters that happened allegedly in the courtroom.
See you today in court, man. I swear to God. He's a good bankruptcy attorney, I promise. But I was like, Chad, listen to me. You don't know what you up against, bro. Listen.
This laughing
It's
is
best you
ridiculous.
just go in and nod, okay? You don't say shit. You just nod, yes or no. Don't say nothing. Chad came out of court today for 3 hours and got his ass towed out the front. And I'm just looking at him. He's like, man. I said, what happened, Chase? You got fined. I said, who got fined? You did. I was like, God. Then he said, we did. I said, wait a minute, we. Hold up. We both got fined? He said, yeah, I got to pay 10% of your attorney fees. I said, what?
So just for simply representing her in this matter, he allegedly got to come out 10% out of his own fucking pocket when she supposed to be paying his ass. You want to talk about bad business, bad for business? Well, you already know who name and face should be in the definition in the dictionary. Because this nigga finna lose credibility in his profession of law. Lose money representing you when you supposed to be paying him. Now his ass is finna be the poster child of losing incredibly and horribly in court. I wouldn't be surprised if he faced potential debarring at some point fucking with you. Man, let me let her continue though, since she wants to turn this into a comedy show. She want to do a Kevin Hart laugh at my pain style video. I won't stop you.
Apparently, it was a shit show today in court. Nobody was prepared. It is what it is. Okay, I said, Chad, listen, I'm used to losing. Okay? I'm used to losing. But I always overcome. Okay? What's the solution, brother? Hey, brother, stay with me. Chad was done. Chad was down for the count. Chad went in there trying to fight that motion. I said, Chad, bro, like, listen to me. He was like, this is going to be a PR nightmare. I said, what are you talking about? I said, Chad, have you seen my brand? It's a PR nightmare. Are you serious? But for my firm, it's going to be a PR. I said, Chad, breathe. Breathe, Chad. We've survived. Like, what I got on? So I got something on? Okay. We have survived the hardest part, okay? This is just merely a bump in the road. We'll do, what did Judge say? Judge said you can't talk about people, you can't talk about them, you can't do that, take it down, okay? And even my content was on it, my logo was on it, take it down. I said, okay, Chad, I'll take it down, no problem.
That's the other part. On all the videos she's been posting for, I couldn't even tell you how long, especially the social media content in particular. She always brands the content with this nigga's law firm promoting it. I thought they had some type of fucking deal going on. I don't know if it was like extra promotion for his firm where it would get reduced costs on her end to have to pay for the services or what. But now that shit is coming back to backfire and bite him in the ass because now his law firm is being attached to her shit as she's getting sanctioned in court for her shit. So it's almost as if he's endorsing it by having his law firm promote it on the defamatory content daily. Now, I've seen some clown shows in my day. I've watched it numerous times. watched Welcome to Derry. You hear me? I done seen Krusty the Clown. I done seen some clowns in my motherfucking day. Homie don't play that. Might be the most relevant one here. But god damn, if this ain't a fucking clown show.
From how much we owe. I don't know, we owe on Monday, but just the order's gonna go in. I was like, oh my God. Oh, I feel sorry for him. He's
Sorry
such a
for
good
him.
guy. He really is. He really is. I said, Chad, listen to me.
Got to ruin this nigga's career.
This has been my life for 9 years. 9 years, okay? At this point, it's like it's a part of the business.
Wow.
Businesses have issues that we have to sort out sometimes.
And she just literally, I don't even know if she knows it. Because I feel like she's trying to, smooth over the situation, make it comical, make it light for her viewers. Because this is what she does. And if you know anything about what she does, like she tries to take all of the negatives and spin them and use them as content or what have you. But in the response from Cardi B, it said that this was a part of your business. They said that you were weaponizing this as your business practice. And you literally just said it's a part of the business. Me getting sued, me losing, me humiliating myself, my family, and everyone else. Now my legal team. Now y'all got to come out of more money, which I'm sure he's going to want to pull back from her reimbursement. You taking everybody down drowning with you and you want to use it as content. Ain't that about a bitch?
Sometimes they're good, sometimes they're not. That is just the nature of the business. In the nature of the business that I'm in, I do get a lot of bad, and I also get an exceptional amount of good, okay? So yes, if you hear, we lost. We lost. We lost the war. We lost the war. But you know what I have? My dignity.
I won't be the judge of that. I can't judge that. She says she got her dignity. So be it. But real shit, man, I just want to go ahead and say, for anybody that's even considering remotely getting into the content creation space, especially if you're trying to get into entertainment news and updates and things of that nature as it pertains to celebrities and just anything of the like you gotta know when to pause, when to stop, when to scale back, and when to move the fuck on. You know what I'm saying? You gotta know how to speak with some level of discretion. Don't let these people gas you up. I love the viewers. But if you start teetering that line of about to drown yourself, they will not come in with a life raft. Some people may donate to your legal fees. They may. We've seen it happen. But they not going to be the ones with their name on legal documentation. Their assets will not be seized, right? So don't let the people gas you up to think you bigger than you really are, that you richer than you really are, that you can go toe to toe with people backed by corporations. It will end badly for you. You know what I'm saying? And not just financially, but with your name then becoming sullied, right? People like this, once upon a time, may have had brands that wanted to associate themselves, give them opportunities, elevate their platform to another level. We're seeing people lose out on those opportunities left and right, especially when it comes to Black creators. Don't put your own foot in your motherfucking mouth. I don't care what type of fetish you got or what type of nasty shit you into. Don't do it. Okay? That's the best I can offer you. Y'all let me know what y'all think of all this down below in the comments. Be sure to like and share this video. If this is your first time seeing me on YouTube, go ahead and subscribe to the channel, become an insider. I will catch y'all on the next one. Hey, man, we need more subscriptions to get to that 40K. You know what I mean? We got to get 40K before the month is out, man. I'm be coming to y'all with a new album soon, man. You know what I mean? Got to hit that 40K. But I see y'all in a minute. Peace.
Yeah, family over fame in this bitch, yeah. The glory of living righteous is setting in. My street knowledge and education's a perfect blend. Young mogul, independent, I've been setting trends. The first one from my family to be faithfully wed. Fuck niggas and the horses that they riding on. I see this shit from all angles like a polygon. I'll never politic and the drama be piling on. Father and greats unacknowledged like I'm Bobby Bonds. Conversation with my lady about the paper route. 5 sit bank accounts every day I make it count. They down talking my commentary for hating now. Well, I can take it cause I'm bodying your favorite now, please. I can do this shit in my sleep. I been writing for these niggas, y'all read it and weep. I been fighting these niggas if you speak on the street. I'll turn your birthday party into New Year's Eve. Don't let me take it there. We ain't playing fair. This the ATL, Southside nigga moving furniture like Wayfair. Life on hold, no insurance for your healthcare. Lifeline gone, so you wanna be a millionaire? Well, let me tell you about this world I built. The women I dodged, the niggas that I read for filth. The sympathy calls, consulting for the stacks I built. I had